Now I'll request Mr. Philippe Billiet, Senior Lawyer and Chief Operating Officer at Association for International Arbitration. He specializes in diplomacy, distribution, retail contracts, commercial arbitration, and mediation. He's a member of the advisory board of the Brussels Diplomatic Academy, BDA, established within the VUB University, and member of the FMB Committee established to evaluate and help setting out a mediation policy for Belgium. He collaborates with the Association for International Arbitration IVZW and is legal counsel to the European Freight and Logistic Leaders Forum, grouping the world leader in the freight and logistics. He works as a lawyer, arbitrator, mediator, and negotiator, and was one of the first international mediators to obtain EMTPJ accreditation. Ladies and gentlemen, your next speaker is Mr. Philippe Billiet.
First of all, I would of course like to thank the organizers to invite me as a speaker to this event. I would also like to congratulate the organizers. This is an excellent event. I think it reaches, or it will reach its goals. I will be talking about mediation, and on my first slide you see a picture. Maybe some of you will know the monument. It is a national symbol of Belgium. It is the atom of an iron. It's an iron atom. It is very strong. And by this picture I would like to suggest an insight in mediation. Mediation requires to get away from a binary view. A binary view, I mean a winner, a loser. We see it all around us. For instance, in sport there is only one winner. We see it in conflicts between parents on the child custody. Mediation is not about right or wrong. Maybe there is no right, maybe there is no wrong, maybe both are wrong, maybe everyone is a bit right. Mediation is about the area behind right and wrong, and not on a binary way, not involving just two parties, but involving everyone who is affected by a dispute, all the actors, and by looking at their affectors, what are their interests. Only like this you come to a solution that is as strong as an atom of an iron. You see that the iron atom has not only two balls, but has several balls. They are all connected with each other. They are all in dialogue with each other. And this symbolizes to me what mediation is. It is not just getting to a solution, but getting to the best solution, the solution that will automatically be supported and be executed because it reflects the interests of all the actors involved in the dispute. Well, I will not repeat the definition of mediation. You have heard it already a few times, but I would also like to share on this point an insight. Mediation is considered nowadays as a form of ADR, alternative dispute resolution. I would suggest let's drop the A and let's replace it by a P, PDR, the principal dispute resolution. The first reflects to a dispute. And this idea is gaining field in Europe nowadays. For instance, countries like Romania, Poland, and many others are considering that the proper way of dealing with a conflict starts with education from a very young age. So there are many projects in schools where children are not punished per se by the teacher, but form themselves a role game. When there is a conflict, another child will help them to communicate, to start a dialogue, and to see if a solution can be found between the children themselves. So this demonstrates that we should start with education to create a proper and effective dispute resolution reflex. Not one where the principle is we litigate and only if we consider something else we will mediate. No, the inverse. I would also like to cite an exception of a multinational company. Maybe some of you know it. It's a Georgia Pacific company. They have done a test some while ago already, in the period 95-2004, where they changed their company dispute resolution management, and they tried to use mainly mediation to deal with conflicts. They did this to around 600 conflicts, and they discovered at the end of the test period that they were able to save $32.78 million. So this is a gigantic amount. This is just the cost saving for a business, but it doesn't take into account yet the commercial advantages, which might be much more than just this amount that I just mentioned to you. I would also like to share a few figures in the European Union. There have been some recent studies that have allowed to share these figures with you. In the EU, the average time of a litigation today is 566 days, whereas the average time of dealing with a dispute, if we would all try to mediate before running to court, before litigating, and taking into account that the average success rate of a mediation is about 70%, so it means that the average time of a dispute would be reduced to 212 days. So it would become less than half the duration of each dispute. The average cost of litigation is around 9,000 euros, whereas if we would all try to mediate before litigating, the average cost would reduce to around 6,000 euros. So there are huge cost savings involved, not only private for the companies to the dispute, but also public costs. How much does it cost for a judiciary, a government, to sustain a dominant litigation forum? We recently did the test in Belgium where we were asked to propose a new mediation law, and we have discovered that for a population of just around 14 million people, which is nothing compared to the population of Pakistan, we would be able to reduce the variable costs. So I'm not even talking about the long-term fixed cost, with around 200 million euros per year. Imagine the benefits for Pakistan if they would apply a same approach. I will share a few more figures on Belgium with you. The average success rate of a mediation in Belgium, depending on the studies conducted, is estimated at between 75% and 85%. So that means that once the parties are able to sit at the table and are assisted by a professional mediator, they are very likely to arrive at a solution. Not only a solution, but the best solution. Also, the monetary value, the average monetary value of a conflict is between 50,000 and 100,000 euros, which is rather high. It suggests that mainly multinational companies have discovered nowadays the advantages of mediation in their cross-border disputes. The average time then of a mediation, also again depending on the study conducted, is 35 days to 45 days, which is very short compared to the average time of a litigation, which is set at around 505 days. The average cost for a mediation in Belgium is, and there the studies differ widely, it's between 3,500 euros and 7,000 euros. The average cost for a litigation is between 12,000 euros and 16,000 euros. These numbers allow us to make a few conclusions. If we take into account the average success rate of a mediation, 75%, so the lower results of the studies, and we would, let's say, each time try to mediate before litigating, the average time of a dispute would become 171 days instead of 505 days. The average cost of a dispute would become 11,000 euros instead of 16,000 euros. So you would save around 330 days per dispute and 5,000 euros per dispute. Another conclusion we can make is that to reach a break-even point, which is a point below which that mediation would not make sense to result in any of these cost and time advantages, then regarding the cost advantage, you would only need 44% of success rate for mediation, where in practice today it is 75%. To obtain the time advantage, you would only need 9% of success rate in mediation in average. So why not mediate? In practice, we see that that these thresholds are reached in each time, suggesting that we should always, in our dispute management, have as a first reflection, let's try mediating, and if that doesn't work, only then let's try litigating. Now, how does it work? I will not repeat the information that others have been said, so I will only try to add some parts. The standard, or let's say internationally the most applied form of mediation is transformative mediation, as opposed to evaluative mediation and as opposed to transformative mediation. So facilitative mediation, I suggest here a model. It is an approach, it is a tool for the mediator, a process through which he guides the parties. And this is a model that we developed with the support of the European Commission. It's called the EMTPJ model. It is taught each year the second half of August in Brussels, where the European Commission is located. And it is a 10-step model through which the mediator guides the parties to arrive to the best possible solution. It's ideal for cross-border commercial and civil disputes. Now, another reason, why should you mediate? Well, it is simple. I think the main advantage of mediation is that you keep your destiny in your own hands. You are boss of your own destiny. You do it together with the other parties. Why would you give your destiny, your future, away to someone else who might listen only a few minutes or maybe a few hours to what happened, who might not understand what happened, what does it do to you, why is it so important to you, and who will rule upon you? That's a huge risk. We are not playing the lottery. We are dealing with our own future. We should take it serious and we should communicate about it. Parties have the opportunity to get to a better situation. Moreover, the alternative, if they litigate, not only is their situation probably or potentially not fully understood, the judge can only do as much as he can do. He has to respect the law. For instance, he has to give damages or give not damages, but he cannot suggest a better agreement for the future that results in more synergies. He can only do what he has to do, conform the law, and that tends to be very restricted. So even the winning party in court can be very, very disappointed because he can only get very limited relief. In a mediation, what does the mediator do? He focuses. And I have a picture of an iceberg. We all know that an iceberg, when it floats, the biggest part is underneath the water. The small part, the part that you can see, is above the water. Now, if we compare the small part with what we can see, the complaint, the arguments, the positions, and the emotions, that is what is being addressed in litigation. That are the tools that the litigator or the arbitrator has to work with. He can see that. But the mediator does something else. He guides the parties to the part underneath the water, which is much bigger, which is the part that makes these symptoms thrive. He asks them for their interests, for their needs, and for their wishes. And these are the tools he works with. Not with the right, the wrong, that's all not relevant in a mediation. The only thing that is relevant is what really matters, because there is a solution that will be sustained for the future. In such way, a mediator also helps the parties to expand the pie. As I said, it's not the aim to get a solution, the aim is to get the best solution. And here the mediator distinguishes between three types of interests: the neutral interests, the common interests, and the opposed interests. The opposed interests are always the most difficult ones, and they tend to be kept until the end. Usually they have a financial character. But by, for instance, applying the neutral interests, why can we not enrich the outcome? Why can I, for instance, do something for the other side that for me doesn't cost anything, but is of great value for the other side? And in this way, we create new values in a dispute, and we maximize the potential synergies in the solution that should be reflected in the solution. Interdependence, especially in a commercial context, it means how dependent am I on the other side? In other ways, why should I stay at the table? And I can assure you that you have many reasons to stay at the table. Because if you leave that table and you go to court, you might lose your supplier, you might lose a customer, and so on and so on. So you have many reasons to stay at the table. The picture also demonstrates something else. You see two dogs carrying one stick. Maybe I should have looked for a heavier stick, but I didn't find one on the internet. What I try to symbolize with this picture is that we separate the people from the problem. The problem is a problem. The people should form a team to deal with that problem. They carry the problem together, they address it together. So we should always, in a mediation, try to see the other side not as the problem, but as a team member for the negotiations to deal with the common problem that might divide us at the beginning of the mediation. Another advantage, and I see there's a lot of media today present in this room, is that mediation is actually confidential. No media present in the mediation room, no journalists, no competitors. Compare this with a court system. In principle, hearings are public. I can assure you, for instance, in Antwerp, one of the capitals for the diamond industry, no diamond trader would ever go to litigation. Of course not. They have their own alternative dispute resolution tools, and they would always emphasize on arbitration or on mediation, for obvious reasons. Also, the focus of a mediation, I have been mentioning synergy quite a few times, is to make sure that 1 + 1 is not 2 but 3. And I'll give a very simple example. Let's say I'm from Belgium. We all know that chocolate is famous in Belgium, so let's give an example with a chocolate pie. Imagine two brothers are fighting over a piece of that chocolate pie, or over the whole chocolate pie, let's say. A fair outcome that we could symbolize with litigation would be we split the pie, half. Does that make them happy? I don't know, maybe. Maybe an even more fair outcome would be we let one hold the knife, split the pie, and the other one will choose which part he takes. Maybe that's even more fair. Will that make them happy? I don't know. What a mediator does is still something else. He asks those two brothers, why do you want a piece of this pie? What do you like in this pie? What is your interest in this pie? And then it could be that one brother says, well, I like the chocolate layer on top. It's more concentrated. Whereas the other one says, I have to think of my figure. I like more the content. And then we don't cut the pie vertically anymore, but we cut it horizontal. And it will for sure make them more happy. And this is what mediation is all about. Listening to the parties, what do they need, what are their interests, cutting the pie in the right way based on the dialogue between the parties. And I see I have arrived at my last slide already. Thank you for your attention.